My name is Cesar Pereira. I'm the chair of the Chartered Institute of Arbitrators Brazil branch. And together with my colleague here, Daniel Nogueira, who is also on the board of directors of the Brazilian branch of CIArb, we are very proud to host this webinar on some very crucial and important issues regarding contract law in Latin America. We are very happy to have here with us today an exceptional lineup of scholars in private law, beginning with Professor Ingeborg Schwenzer, known certainly to all of you in our audience. Professor Schwenzer is Professor Emerita from the University of Basel in private law and author and editor of the most renowned commentary on the CISG, which is, as you all know, part of the national law of many Latin American countries. We also have with us Professor Edgardo Muñoz from Universidad Panamericana, Guadalajara, Professor Rodrigo Momberg from the Catholic University of Valparaíso in Chile, and Professor Renata Steiner from the University of Mackenzie in São Paulo, Brazil. So with that group, we will certainly be able to discuss in depth some absolutely unavoidable issues that we must face now with regard to contract law in Latin America. I don't even need to say that, but as you all know, we are facing today a context in the economy and in contract relationships and in the world in all kinds of aspects that is unprecedented, is absolutely unpredictable, and that creates all kinds of discussions with regard to how to deal with contracts, what type and what extent of interference, if any, should a judge or an arbitrator be allowed in this context, whether we do have sufficient laws to deal with these issues, or whether we need our national congresses to enact specific legislation. These are all issues that we will be very privileged to be able to discuss with our speakers today. Unless Daniel has any other remarks at this stage, I will again thanking our speakers and thanking our audience for being here and attending this discussion. I will, without taking any more time from our speakers, I will turn to Professor Ingeborg Schwenzer for her presentation. Ingeborg, the floor is yours. Thank you.
Thank you very much, Cesar. First of all, I wanted to thank you very much for organizing this wonderful virtual event. Welcome all of you. Good morning, good afternoon, good evening. First of all, Cesar, could you please activate my screen? It's still deactivated. Okay. So again, welcome everybody. Sorry for the short delay. I called my presentation today CISG and PICC UNIDROIT Principles in COVID-19 Times. So first, what I'm going to talk about After a very short introduction, I'll discuss the possible legal basis under the CISG and under the UNIDROIT principles. And then we ask ourselves the question whether COVID-19 is a force majeure event or whether it might lead to hardship in international contracts. And then briefly, I will touch upon the possible remedies and finally conclude. Cesar Pereira already mentioned it. COVID-19 has hit global trade at an unprecedented speed and scale. Manufacturer factories have been shut down. We had a breakdown of supply chains, increase in costs, and breakdown for market for buyers. So this all leads us to the question, how can we use the existing international sets of rules to deal with all of these cases? So let me turn to the possible legal basis. Like with any contractual problems, the first question is, did the parties provide in their contract for a force majeure or hardship clause? Parties are advised to do so beforehand, and they might have done by inserting an ICC force majeure or hardship clause. Up to now, we had the force majeure and hardship clauses of 2003, and these have been revised, and we now have new force majeure and hardship clauses of 2020, especially the hardship clause has been slightly amended in view of the international developments, especially as regards the remedies for hardship. So if the parties have not provided in their contract for any such a clause, in an international contract, we may either rely on the CISG or on the UNIDROIT principles. The CISG, as you know, the United Nations Convention on Contracts for the International Sale of Goods, that has been in force in Brazil for a couple of years now, and that is in force in altogether 93 countries in the world, thus covering more than 80% of international trade, covers the sales contract. So only if we do have a sales contract, the CISG comes into play. And the core provision is Article 11A of the CISG. The CISG applies if both parties' places of business are in CISG member states. For commercial parties from Brazil, this means that most of Brazil's export and import trade potentially is covered by the CISG if the parties have not excluded the CISG. The CISG contains Article 79, and 79 CISG clearly covers force majeure, and as regards now the prevailing opinion in case law as well as in scholarly writing is that the same provision, Article 79 CISG, also covers cases of hardship. If we do not have a sales contract governed by the CISG, we might apply the UNIDROIT principles on international commercial contracts, PICC principles on international commercial contracts. They govern any contract, not just contracts for the sale of goods, and they apply not like the CISG by its own, but only if the parties have chosen the UNIDROIT principles, or if they have chosen the lex mercatoria to govern their contract. The UNIDROIT principles contain different principles. They do have a force majeure provision in Article 7.1.7, but additionally, they also have provisions on hardship and the core provision is 6.2.2 of the UNIDROIT principles. Let's briefly turn to the relevant statutory provisions. Article 79 CISG, a party is not liable for failure to perform any of his obligations if he proves that the failure was due to an impediment beyond his control and that he could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract, or to have avoided or overcome it or its consequences. So under Article 79, for an exemption of the seller or of the buyer, we need three prerequisites. We have an impediment beyond the control of the party, and this impediment was not foreseeable at the time of the conclusion of the contract and not avoidable when it came into being. So those are the three prerequisites under Article 79. More or less, we have the same prerequisites under the UNIDROIT principles: impediment beyond its control, not foreseeable, and not avoidable. As I already mentioned, Article 79 of the CISG also applies to cases of hardship, whereas the UNIDROIT principles do have a separate provision on hardship. And there we can find there is hardship where the occurrence of events fundamentally alters the equilibrium of the contract. So that is the first prerequisite, fundamental altering of the equilibrium of the contract. And these must be due to events that occur or become known after the conclusion of the contract. Again, like in Article 79 of the CISG, the events could not reasonably have been taken into account by the disadvantaged party at the time of the conclusion of the contract, were not foreseeable. With other words, the events are beyond the control of the disadvantaged party, and the risk of the events was not assumed by the disadvantaged party. So this is the legal basis from which to start. We start now to ask ourselves, what has happened during the COVID-19 crisis? Can the COVID-19 crisis be a force majeure or hardship, and what are the consequences for the parties, for the contracts affected by this worldwide crisis? First of all, pandemia as such is usually regarded as being a force majeure event. It is provided for in the force majeure clauses by the ICC. Epidemics and pandemias are mentioned there explicitly. The question is, does this amount to an impediment hindering performance? And when discussing this question, we must have a look at the different situations, at the different problems that COVID-19 has created. There may be the shutdown of a factory, of a manufacturer, who at the same time is the seller of the goods. This is a clear-cut force majeure event. The seller is not able to manufacture the goods and thus to deliver the goods. And this is also clearly an impediment beyond the control of the seller in this case. The same applies to cases of export prohibition, where the seller is prohibited from exporting some goods to another destination, as has been the case, especially with protective tools So this is also clearly a force majeure event and will lead to an application of Article 79 of the CISG. There are more and more difficult problems with the failure in the supply chain, because under Article 79 of the CISG, a failure in the supply chain is not an impediment beyond the control of the seller, except where the parties have explicitly foreseen the relevant person as a supplier. The same applies to increase of costs. Increase of costs are certainly not an impediment that hinders performance of the contract, but increase of costs, as we have seen now during the COVID-19 crisis, tremendous increase of costs, not only in producing, in the manufacture of products, because the manufacturer has to adhere to certain security standards, but also increase of transportation costs that hardly or that were never foreseen. These problems might give rise to a discussion of hardship, but they are certainly not a force majeure event because they do not hinder performance in itself. They make performance much more onerous for the party. Likewise, a breakdown of the buyer's market, as we have also experienced it in these times, does not release the buyer from accepting the goods, from taking delivery of the goods, and from paying the purchase price in itself. It's not an impediment hindering performance by the buyer, but rather it might amount to hardship, and we will have to discuss whether this was extremely onerous for the party affected by this. Let me briefly turn to the remedies, because as César Pereira mentioned in the beginning, that's a very important question. Do we need additional laws, additional rules for these cases? So let's have a look at the remedies first regarding force majeure. If we look at Article 79 of the CISG, we find the consequence of a force majeure event or any impediment beyond the control of the aggrieved party is exemption. Exemption means exemption from paying damages. There is still a breach.
We lost Professor Schwenzer?
I think so. Well, I cannot, you got frozen there.
This is part of the new logistics of events online. We have technical issues now as a part of taking care of the events. Professor, are you back? Your microphone is off. Your microphone is off.
Thank you. I'm just looking whether.
There we go.
Okay. Somehow I was thrown out. So hopefully the COVID-19 crisis is only temporary. That means we face a temporary impediment, and both the CISG as well as the UNIDROIT principles take care of such temporary impediments. The exemption only has effect for the period during which the impediment exists. Once there is no longer an impediment, the factory is no longer shut down, then the seller again is obliged to deliver the goods promised under the contract. What is not affected by the impediment is the right to avoid the contract, especially by the other party. The other party may avoid the contract if the non-performance by the seller, for example, leads to a fundamental breach of contract. Let's have a brief look at the remedies for hardship. First of all, again, contract clauses contain remedies for hardship, and the new hardship clause under the new ICC hardship clause has several alternatives from which the parties may choose whether they want a clause that they have a duty to renegotiate the contract, or whether the court or tribunal may adapt the contract or terminate the contract. So the parties are free to provide for the remedies. Likewise, as in their contract clauses, they can provide for the threshold for hardship. Under the CISG, I said the CISG also covers hardship. For hardship, we have the same remedies as for force majeure under Article 79 CISG. That means that we have an exemption from the liability in damages, and specific performance is excluded, but there are no other or different remedies between force majeure and hardship under the CISG. This is different in the UNIDROIT principles. There, the primary duty of the parties is to renegotiate the contract in case of hardship, and upon failure to reach an agreement, the court or tribunal may either terminate the contract or adapt the contract with a view to restoring its equilibrium. Unfortunately, there is no time here to discuss whether these remedies are, in my view, appropriate or not. I think the CISG is enough also in this situation to lead to fair and reasonable results. Thus, I come to my conclusion. COVID-19 can be a force majeure or a hardship event. It's primarily up to the parties to provide for contractual clauses dealing with situations of force majeure and hardship. The CISG and the UNIDROIT principles cover these situations, and in my view, they are more predictable and better suited than any domestic contract law that I know, and at least at the international level, there is no need to have any further legislation. Thank you very much.
Thank you very much, Professor Schwenzer, for your brilliant contribution. We will leave the Q&A to the end of the session after everyone has spoken. So I have a couple of questions, but I'll reserve them for later. In the meantime, it's my pleasure and my honor to introduce my friend, Professor Edgardo Muñoz. He's a professor of law at the Universidad Panamericana in Guadalajara, Mexico. He's an arbitrator, counsel, legal expert in domestic and international arbitral proceedings, a authority on international law in his own right. Professor Edgardo, the floor is yours.
Thank you. Thank you very much, Daniel. It's a great pleasure to to be with you today. Thanks to the Brazilian branch for organizing this beautiful event, where we will be able to discuss different approaches that different instrument countries take to this pandemic. My presentation is titled Mexico Will One of the Last Guardians of the Pacta Sunt Servanda Resist? And the question is fair. It's fair because Mexico is one of these civil law countries that have, at least at the level of business to business, and resist business to business national contracts resist to I don't know if call it the need or the temptation to change their impossibility regulations, norms, to make them more flexible. In few words, in Mexico, the rebus sic stantibus clause hasn't been implemented in our own law. So I'm gonna start my presentation by telling you a bit what happened and how our contract law is organized. In Mexico, since middle of March, there were some of the states, federated states, already taking measures to tackle the COVID. But our federal government, Mexico is a federation as Brazil, our federal government did not issue a decree until the 30th of March. And this decree was titled Sanitary Emergencies for Reasons of Force Majeure. So the title is very revealing, and it was actually appropriate that they titled it Reasons of Force Majeure, because in Mexico there has been this distinction between act of God and force majeure events. If they would have used act of God or caso fortuito, which is a term in Spanish, they would have given the focus on the pandemic itself. But by titling force majeure, they give more importance to the decree itself that actually listed the type of activities, commercial activities, social activities that were permitted, and also listed those who would not be permitted as from that time up until actually this week, where we are starting to reactivate the economy. So as Professor Schwenzer already introduced, this decree in Mexico caused that certain activities couldn't simply be performed, and some contract related to those activities could not simply be performed, while others became more difficult, even because the market of that specific contract disappeared, or because the channels of distribution had certain difficulties in being implemented. So the focus of everyone in Mexico and elsewhere in the world was on the type of provisions that we have in Mexico to address this sort of impediments. And in Mexico, the things are a bit complicated because we follow the French tradition that still divides our applicable law to the contract in at least 3 different main bodies of rules, or 3 different types of contracts. We have, on the one hand, the B2B, business to business contracts governed by the Code of Commerce. Our Code of Commerce is something that still has a lot of relevance, because many countries have been governed for many years through that code. We have the Civil Code. Actually, I correct myself. We have 33 civil codes, each per state, that govern the activities between consumer to consumer. So every state has its own civil code. And then we have the consumer protection law, which governs B2C, business to consumer transactions. So I'm not gonna, I'm gonna focus on the B2B, which is the business to business. And besides the fact that our commercial code is very comprehensive, it doesn't deal with every aspect. So we have a federal civil code to supplement not only the Code of Commerce, but many other commercial or federal laws that have been issued over the times in Mexico. And neither the Code of Commerce nor the Civil Federal Code contemplate the possibility of hardship events. I mean, if an event becomes more onerous, that does not amount to impossibility. It doesn't amount to force majeure. It doesn't amount to act of God. Simply, the parties must perform the contract, and if they cannot do that, well, because it's indeed impossible, the breaching party will be released from the obligation to pay damages. It won't be forced to comply with the contract, and the other party may eventually avoid the contract because it has lost any interest. But if the contract has simply become more onerous or more difficult to be performed, there is no remedies for that. It's a breach of contract. Damages may be claimed by the creditor, and therefore, yes, the obligee must comply. This, of course, may not be fair in many instances. And because of the state of the law so far, what happened is that the government started, through their commissions and secretaries, started to reach some agreements. For example, there was an agreement with banks. The National Banking Commission agreed with the banks, main banks in Mexico, that interest would not be imposed or charged. No penalties on failure to pay interest will take place for the next 4 months. We also have the Finances and Securities Commission negotiated, and Insurance Commission negotiated with the main insurance companies that they will cover any events or any sickness related to COVID, and that they would not distribute any profits among the shareholders, so that they have full pockets to address any eventuality that may occur during this time. And there were also other specific matters, for example, for leases, but this would be C2C leases, not commercial leases. So for C2C leases, consumer to consumer leases, there were some states that enacted new laws suspending in some circumstances the obligation to pay the lease. My presentation is titled in a way and with a question mark, and this is fair on the one hand because not all the Mexican legal system, contract legal system, is strict to follow all times the pacta sunt servanda, because as I said, several states have their own civil codes, and for C2C matters, some states have already adopted provisions on hardship. So, but these civil codes, which pertain to C2C matters, are not applicable to commercial contracts, which are perhaps the more important contracts for their amount of money involved. But besides that, Mexico is also a contracting state of the Vienna Convention on the sale of goods. And as Professor Schwenzer already mentioned, Article 79 of that convention that applies to contracts that are governed by Mexican law and that have the character of an international sale will benefit of a different concept of impediment. not of impossibility like the traditional Mexican law that it should be really impossible to perform, but in a way to a proper interpretation of 79 CISG that would allow in some instances to release a party from the obligations to pay damages in case the circumstances, economic circumstances, change to an extent that has almost become impossible to perform. But if we are dealing with pure Mexican law, which is the case in some contracts, there would be not much possibility to change the basic obligations that the parties negotiated from the outset. However, this may be changed soon. There have been some signals from the government in an attempt to make or incorporate some hardship provisions to deal with this situation. And the will to do that is actually related to arbitration and big contracts. As many of you know, Mexico at the beginning of last year, 2019, got involved in at least in around 10 arbitrations under the rules of the LCIA, the ICC, where Mexico is suing foreign companies that agree to build, install, deliver, and also provide some of the natural gas that Mexico buys from North America. The argument that Mexico raised is that two arguments: that the contracts were unfair and that the circumstances have changed. Those contracts are governed by Mexican law, and Mexico is the seat of arbitration. So for the own government of Mexico, it would be very difficult to convince an arbitral tribunal that Mexican's provisions should be read differently that they have been read through all the years, at least the hardship provisions on Mexican national law. And the other, these arbitrations, by the way, they have been suspended, temporarily suspended, because the government wants to or is willing now to renegotiate those arbitrations that are for thousands of millions of dollars. And the other signal that I see that may lead Mexico to incorporate hardship in their provisions, in commercial law provisions, is that during the pandemic, during the COVID, Mexico has refused Pemex, which you know is the Mexican petroleum company, national petroleum company. In the news, it has been reported that Pemex has refused to take delivery of several cargos of gasoline, invoking partial force majeure. I don't know what law governs those contracts, but at least in Mexico, there is no such a partial force majeure that Mexico is now invoking because of a crackdown of the market for gasoline. As I don't know if that happens in Brazil, but in Mexico, the price of gasoline is now very low. I mean, people is not using their cars. So I would conclude with that. In Mexico, the clausula rebus sic stantibus does not exist for purely national B2B, business-to-business contracts. We have the possibility to invoke the CISG Article 79 for those sales governed by the CISG. Usage or application of the UNIDROIT principles, as Madam Ingeborg Schwenzer already said, would allow some of the parties to rely also on hardship provisions. And for C2C contract, some states, some Mexican federated states have provisions on hardship, and they would be able to invoke as soon as the courts open because they are closed so far. So another of these things that happen, I mean, the law is there, but we cannot apply the law. So thank you very much for your attention. It's been a pleasure to be with you, and I remain available for any question you may have.
Thank you, Edgardo. Once again, the questions will be presented at the end so that we can have a discussion Q&A with everyone involved. In the meantime, it's my honor to invite Professor Rodrigo Momberg to discuss adaptation and renegotiation of contracts in Latin America. Professor Momberg is Professor of Private Law of the Catholic University of Valparaíso in Chile. He's counsel and legal expert in arbitral and commercial proceedings. Professor Rodrigo, the floor is yours.
Okay, thank you very much. First of all, well, good morning, everyone, and I want to thank Dr. Pereira for the kind invitation to participate in this seminar with such excellent speakers, really. So I'm going to share my, yeah, I think I'm sharing now the screen of my computer, if you can tell me.
Yes.
Okay, excellent. Good. Yeah, I'm going to say some general ideas, really, because the time is limited, of course, and about adaptation and renegotiation of contracts in Latin America. Adaptation and renegotiation is always linked to hypothesis of hardship or change of circumstances, or as we call it in Spanish, imprevisión. And this is an important, I don't have to say it, important subject in these times. So just give me a moment. Yeah, there's better. As Professor Schwenzer said, all this emergency, all this pandemia, it has just such severe effects, economic and social disruptions. So I will focus in some Latin American jurisdictions, but of course, just in a general overview. I don't have the time, and I don't want to be arrogant to say that I'm an expert on all of that, all of those jurisdictions. But I can say some things about it, and then I'm going to make some final conclusions about the necessity or not, and the state of the art about the revision of contracts in case of extraordinary circumstances like we are living now. So let's start as a matter of historical observation. Latin American civil codes of the 19th century, and really those enacted on the first half of the 20th century, following their European sources, didn't include any general provision on change of circumstances. But the severe economic circumstances and social changes of the 20th century, as well as the influence of modern civil codes and the reception of new legal theories, such as the socialization of private law, solidarity in contract law, led to the inclusion of rules on change of circumstances in the reform or the enactment of Latin American civil and commercial codes during the or after the second part of the 20th century. So I have made a classification of Latin American jurisdictions. Of course, they are not all included here, just a bunch of Latin American jurisdictions between receptive and unreceptive legal systems in this matter, based on the readiness or not of the specific legal system to recognize situations of change of circumstances as being legally relevant, and therefore granting the possibility to the affected party to rely on a system of remedies in that case. So, for instance, we find as receptive legal systems Argentina, Bolivia, Brazil, Colombia, Guatemala, Paraguay, Peru, and as unreceptive legal systems, Chile, Mexico. This is based on Edgardo's presentation, Uruguay, and Venezuela. As I said, this is not a complete panorama, but it's just an example of some of the most important jurisdictions in Latin America. So I will say now some things about some of these receptive or unreceptive legal systems. Let's see first in the case of Argentina. In this original version, the former Argentinian civil code, the civil code of Vélez Sarsfield, strongly supported the principles of freedom of contract and pacta sunt servanda. And the imprevisión theory was incorporated only in the year 1968 by Article 1198. Since then, Argentinian legal theory and case law have developed, I would say, a consistent and relevant doctrine with regard to the subject of unexpected circumstances. And this has been widely analyzed in theory, and I think most importantly, have been tested in practice, especially in periods of economic crisis, which have affected Argentina since 1975. And because of that, it's not a surprise that the Commercial and Civil Code of 2015 includes expressly imprevisión on its Article 1091. So, according to that provision, it is imprevisión. It's applicable in the case of commutative contract for deferred or continuous performance. In the case of the performance of one of the obligations or the obligations of one of the parties has become excessively onerous because of extraordinary alternation of the circumstances. All of these linked to supervening and external causes. And if it is not a risk assumed by the affected party. One kind of oddly, I would say, feature of this new provision is that enforceability is not mentioned in the provision. Because enforceability is a traditional and common condition for the operation of hardship or imprevisión. And there is a discussion, as far as I know, in Argentinian legal doctrine on the necessity or not that this supervening and external and extraordinary circumstance is should be also unforeseeable for the affected party. But for me, it's a kind of weird that a provision on unforeseen circumstances does not mention really that this event or circumstance should be unforeseeable. With regard to the remedies, the affected party may have the right to request the partial or total termination of the contract or the adaptation of the contract, in all cases by the judge. If we go to another jurisdiction, and I'm just going to say a couple of words about it because I know that there are people here that knows more than me on Brazilian law. So the Civil Code of 2002 also includes the regulation of excessive onerosity under the title of termination by excessive onerosity, again, in the case or applicable to contract for continuous or deferred performance, and with the requirement that this extraordinary and unforeseeable event makes excessively onerous the performance of one of the parties, but with one, I think, very interesting addition, that this excessive onerosity also must imply an extreme advantage to the other party. So in a way is a restriction for the applicability of these provisions. Not only excessive onerosity, but also an extreme advantage to the other party. With regard to the remedies available for the affected party again can request the termination of the contract, but at least not in the text of the provision. I'm not sure what happened in judicial practice, but he does not have the right to request adaptation of the contract or revision of the contract by a judge or an arbitrator, just termination following the Codice Civile, that it's with the same remedy. And the advantage party may propose an equitable modification of the contract if he wants to avoid termination. What happened in Colombia? There is no provision on the civil code. The Colombian civil code is largely based on the Chilean civil code, the Andrés Bello civil code, but there is a limited recognition of imprevisión based in another general, I would say, principles of law by the case law. But it is expressly recognized by the Commercial Code of 1971, Article 868, which allows the revision of the contract by extraordinary circumstances. Again, in contracts of for successive, periodic, or deferred performance, in the case of extraordinary, unforeseen, or unforeseeable circumstances, which makes excessively onerous the performance of one party. The remedy available is request for the affected party the revision of the contract by the judge, which, if possible, is allowed. The judge can make equitable adjustments to the contract. That, for me, at least, sounds a little bit dangerous. If this equitable adjustment is not possible, the judge may decide or decree the termination of the contract. And finally, with regard with these receptive legal systems, we have Peru, also with an express recognition of the excessive onerosity of the obligation in its Civil Code of 1984. This is more or less similar to what we have been talking about with regard to the conditions of application, commutative contracts for continuous, periodic, or deferred performance, also exceptionally applicable in to other contracts. I'm not going to stop here. Again, in case of excessive onerosity because of extraordinary and unforeseeable events. With regard to the remedies, it is interesting that the code provides for the adaptation of the contract by the judge in order to remove the excessive onerosity. I think this is, I like this statement of the Peruvian Civil Code, because does not make any reference to subjective, or I would say liquid concepts like equity or fairness. So adaptation has to be directed to remove the excessive onerosity of the contract. What happened to unreceptive legal systems? We have here, for instance, Uruguay, no provision in the civil code regarding change of circumstances or improvisation, but also the case law in Uruguay has rejected the application of improvisation or hardship in cases of excessive onerosity. What happened in Chile? We have no provision in our civil code, Andrés Bello's civil code. In fact, the code have a strong recognition of the pacta sunt servanda principle based on Article 1134 of the French Civil Code. It's our Article 1545. Contracts lawfully entered into are a law for the contracted parties and cannot be invalidated except by mutual consent or for causes authorized by law. Legal doctrine, especially contemporary legal doctrine, I think is in favor of the admission of a restricted and limited admission of improvisation in some exceptional cases based on other provision of the code, Article 1546, which provides for the principle of good faith in the performance of contracts. But our case law, especially the Supreme Court case law, has consistently rejected the application of hardship or improvisation with regard to contracts, especially private law. So in its last decision regarding the subject, was very clear about the rejection of this theory. The court said something like, neither Article 1446 nor Article 1460, which provides for the interpretation of the contract on the basis of the parties' intention, are legal grounds to invoke improvisation, because neither the duty of good faith nor the intention of the parties are contravened if the creditor claims the performance of the contract as agreed. So we have some, just a couple really, and literally just a couple of decisions of lower courts, some one or two of courts of appeals and another of courts of first instance that admits improvisation. But I have to say that our Supreme Court has not yet issued a decision applicating with the admission of the improvisation theory, and on the contrary, it has rejected its application. If we go to arbitral decisions, then the situation changed a little bit, but not too much. I mean, there is a limited acceptance of improvisation, and but again, just like extraordinary and exceptional remedy. And the problem is that there is a lack of uniformity in these arbitral decisions with regard to the conditions or requirements for improvisation to be applied, and especially with regard to the remedies available for the parties, because some decisions decided for the termination of the agreement with no room for adaptation, and other decisions have revised the contract and adapted to the new circumstances. So the panorama is not really settled yet in this matter. As a conclusion, I think that in Latin America, it is a clear trend towards the acceptance of imprevisión, I should say that any new reform of substantive reform of a civil code in Latin America or the enactment of a new civil code will include a provision on imprevisión, but there is no yet, I think, a clear agreement on which is the system of remedies for imprevisión, especially if we revise again the provisions that I show you. There is no mention, for instance, to renegotiation of contract as the first available remedy for the parties. That I think is the best option. So maybe a good model is this provision that is included in the principles of Latin American contract law, an academic endeavor published in 2017, which follows more or less closely the model of the UNIDROIT principles that Professor Schwenzer showed us in the first presentation, but I think can be a good model. If we need some kind of special legislation for these extraordinary times, these times of COVID or pandemic, I think that is not really an easy question, and it's really a difficult answer. Maybe we need it, but if we do it, we have to, in any case, it should be always of exceptional application, of a temporary nature, just for a limited period of time, and ideally for a specific economic sectors. I'm not, I don't agree with a general provision, a drafting of a general provision in these times, because we need enough thinking about it, enough reflection, and we need to have a good, we cannot introduce, for instance, a new provision in our civil codes based on what is happening now. Maybe some sector specific provisions or emergency legislation is fine, but not a general legislation. The pandemic is clearly an extraordinary and unforeseeable event. But the question is, we have to bear in mind if this extraordinary and unforeseeable event makes the obligation, the performance of the obligation of the contract impossible or excessively onerous. Because if that is not the case, the contract has to be complied, just application of the general principle, pacta, sunt, servanda. So thank you very much. And yeah, I will be happy to answer any question after the last presentation. Thank you.
Thank you, Professor Rodrigo. Speaking of coming up with laws to deal with the pandemic, Brazil has been very active in that field. At least there are a lot of legislative proposals. And since we're speaking about Brazil now, let's segue into Professor Renata Steiner's presentation on force majeure and possibility in Brazil. Professor Renata Steiner, as we know, is a private law professor at the Universidade Presbiteriana Mackenzie. She's also an arbitrator in counsel and commercial arbitral proceedings, and she will be discussing Brazilian law and how Brazilian law deals with this situation. So, Professor Steiner, you have the floor.
Thank you, Daniel. Well, good morning, good afternoon to you all. I would like to start thanking the CIArb for the kind invitation. It's a huge pleasure to be able to share some thoughts on Brazilian law with you, and also an honor to hear Professor Schwenzer, Professor Muñoz, and Professor Momberg. So thank you very much. Well, in my presentation, I will address some general remarks on how this Brazilian civil code deal with some of the problems, of the contractual problems caused by the coronavirus pandemic. I'm not, of course, I won't be able to provide you a full panorama, so I've chosen to speak about some specific issues, and my focus will be commercial contracts, so I'm not focusing on consumers' contracts. Well, to do that, first, I'd like to point out a fact that has already been pointed out by the previous presentations, is that it goes without saying that this pandemic will, or as a matter of fact, has already impacted many of the contracts in course. Not all of them will be impacted, but in amongst them, those impacted, they will not, of course, be impacted in the same intensity. But it doesn't matter. I think in the world you're listening to us from, you understand exactly what kind of problems or legal problems this pandemic may cause to a country. So the problems are kind of universal. Professor Schwenzer has already pointed out some of the problems. I'd like to point out some other problems that in the legal perspective will be caused or are ongoing to the contracts. For instance, temporary obstacles to perform or to receive performance, increasing cost of performance, decrease in value of the performance, and increase or decrease in costs associated with the performance. So that being said, we have a universal problem that has to be solved either by the parties who can agree to a solution previously in the contract, for instance, in a hardship clause, or in a force majeure clause, or in a review clause in a contract, or after this pandemic occurs by renegotiating the contracts. But in case parties are not able to find a solution, then we have to look at the legal system that governs the domestic law or the international conventions such as the CISG, or a lex mercatoria rule, such as the droit principles that governs the contract. So although we have a universal problem, we have a local solution to that specific contract. And that leads us to the question: how does Brazilian law? That's my that's what I want to talk about. That's my subject matter. How does Brazilian law deal with these problems that I've just raised? I've chosen to speak about two figures, namely the impossibility of performance and force majeure. But in order to make clear why I chose to speak of those two, and considering the previous presentations that have talked about that, spoken about hardship, I will also briefly talk about hardship, although it's not actually what I intended to do. So Brazilian law, we find rules of impossibility and force majeure, and also change of circumstances that I'm calling here hardship, just to make it easier. So there is a controversy that's actually a hardship clause. But to start with, impossibility in Brazilian civil code, and I'm talking about impossibility that happens after the conclusion of the contract. There are three main rules that rules impossibility in Brazil. The first one, it's found in Article 234 that deals with the loss of the object. The second one is Article 248 that deals with the impossibility in intuito personae to do obligations. And finally, Article 250 that deals with the impossibility in not to do obligations. So we have these three rules, and I'm not gonna, of course, read it to you, but trust me, they don't define what it's to be understood, what's impossibility in Brazil. So there is no legal definition of impossibility in Brazilian law. One could argue, well, but that goes without saying. We know what's impossible what's impossibility to perform. I would honestly disagree to that. If we think, for instance, that there are different definitions of impossibility in different domestic laws, and I would just make a brief mention to the German Civil Code, for instance, that in the reform from 2002 has added in paragraph 275 the economical impossibility that was recognized by case law, but wasn't actually recognized by the BGB, meaning that we can understand impossibility in different ways. Of course, there is this natural impossibility that goes, for example, the object has been destroyed by a fire, but we have to actually think that this kind of real and factual impossibility is normally normally does not happen. We normally have other kinds of impossibility that are not the natural ones. So despite of the legal definition, Brazilian scholars could find one, but I have to be honest and say to you that there is no study in Brazil that really focus on the impossibility to perform. So usually the impossibility is found just in textbooks for law of obligations and in a very brief pages. So it's not really a topic that has been studied in Brazil. Brazilian scholars would agree that the definition of impossibility in those articles I've just mentioned is that impossibility that's absolute, meaning that it's factually impossible to perform, not only more difficult to perform, objective, that affects not only the debtor, but also anyone, no one can perform. And the most important thing, I think, in my opinion nowadays, is that the impossibility must be definitive and not temporary. So meaning that we have to have these three qualifications in order to apply those rules. And that, I repeat, does not comes from the Brazilian legislator, but from Brazilian scholars. And that's not actually a criticism. I'm just pointing out what's the state of art of the impossibility in Brazil. However, the rule, it does not define impossibility, but it fixes the consequences applicable to the impossibility. And these consequences are two, and they depend on the existence of fault. So if there is no fault from the debtor, then we have a termination of the obligation ex lege ipso iure automatically, meaning that there is simply the contract is terminated, or that relevant obligation is terminated. However, if debtor has acted with fault, then we have a situation of breach of contract. And this situation of breach of contract will be ruled by other rules in Brazilian Civil Code that do not actually refer to impossibility, but it goes without saying that impossibility is one way of breaching the contract, like causing the impossibility is a way to breach the contract. And some scholars would say that in the breach of contract, for instance, the impossibility to perform can also be understood as the loss of interest of creditor, but that's not actually our focus here. But as we're speaking of fault, that leads us to the second figure I'd like to talk about, which is the force majeure rule. We have a force majeure rule in Article 393 in Brazilian Civil Code, which is one exemption of liability rule. Differently from the rules on impossibility, here the Brazilian legislator has provided a definition of what is to be understood under the term force majeure. It also treats the fortuitous event together with force majeure. Just to make it easier, I'm just referring to force majeure because it doesn't have really a huge difference between consequential between these two figures. Well, what's a force majeure? It's an event beyond the control of the parties whose effect could not have been avoided nor prevented. It's actually, I think it's also a universal definition of force majeure. However, here we have a definition, but we don't have the full legislation. The legislation does not address fully the consequences applicable to force majeure, because it just states a debtor is not liable for damages. But it does not say, for instance, what happens to the contract and what happens to the duty to perform. We know that the performance has not occurred due to a force majeure, but we don't know if debtor is still liable to perform, and not how long will he stay liable to perform, and so attached to that relevant contract. And this is so because the force majeure rule is usually combined with another rule that dictates these consequences applicable to the contract. I would say that the force majeure rule is not, at least I'm speaking, of course, of Brazilian perspective, it's not a rule that stands alone. So we have to understand this rule always with another rule that will address the consequences to the contract. One could argue then that the force majeure rule could be combined with the impossibility rules that I just mentioned, and that's partially correct. As long as a force majeure event occurs that also renders the performance impossible in a definitive way, then we have the full panorama. We have the consequences very well established. We have termination and we have the exemption of liability to debtor. However, if we think of, for instance, in temporary impossibility that can happen due to a force majeure event, we won't find, at least not in the way Brazilian scholars understand impossibility, we won't find a solution to that, even if we combine this two figures. And moreover, none of these figures combined, force majeure or impossibility, will provide solutions to some situations in which there is no impossibility, but there is a difficulty in performing, and this difficulty could sometimes render it almost impossible to force the debtor to perform. But that's not an impossibility in the way Brazilian scholars understand impossibility, to apply the rules on impossibility, meaning that we have a problem to be solved. Usually these kinds of problems where we have a difficulty of the performance would be solved by the hardship clause, and that's why I wanted to say something about the rules on hardship in Brazil. Rodrigo has already mentioned it. We have a very peculiar article on hardship in Brazil. So the article is 478. It states that in long-term contracts, actually what's very important is that the performance is not at the same time as the execution of the contract. So it's not actually a long-term contract necessarily, but usually, just to make it easier, I'm referring to it as such. So in a long-term contracts, they may be terminated if performance becomes extremely onerous due to extraordinary and unforeseeable events, as long as there is also an extreme advantage to the other party. This last sentence that I've highlighted, I did it just to show you that this is a peculiarity of Brazilian law. One could understand that, well, it's to see if a performance is rendered extremely onerous, one has to look between the equilibrium between the performance and counter-performance. But that's not only what this article is about. It actually requires that the other party profits from this this extremely onerosity. And that's actually a high standard that's not very easily fulfilled. As I was preparing this presentation, I took a look at a recent commentary on this article from a preeminent scholar in Brazil, Professor Schreiber, and he said, and I thought it was very interesting because he was criticizing some scholars that say, well, we can simply disconsider this last sentence, and as long as there is extremely onerosity, we don't have to look at extreme advantage. Otherwise, it's going to be a high standard that will not be easily achieved. And then he said that, well, that's just has an inconvenience. And then he used this quotation mark to point out the inconvenience of this is to simply disconsiders what the legislator has chosen, and that's actually a very bad sign of interpretation here in Article 478. And moreover, just to mention, there is a project of a statute of law that's still ongoing in Brazilian Parliament that will perhaps, if approved, will have a rule on review of judicial review of contracts, stating that there is no extraordinary event, for instance, in inflation or currency variation. This is it's not a definitive rule, it's just a temporary rule that would deal with the problems caused by the coronavirus pandemic. But if approved, then we have two problems in relying on this article. The first one is that as per its wording, it's really, the high standards are hard to fulfill. The second one is that the case law standards and this new case law, this new law also fixes a high standard of what is to be understood regarding extraordinary and unforeseeable events. And still, even if it were not the case, we also have some problems in relying on this hardship provision in Brazilian Civil Code, because there are many situations in which it's not the performance that itself that it's rendered more onerous, but other provisions, and this rule refers to to performance. Yeah, let's think, for instance, in take or pay obligations or bill to suit obligations, when one has to pay even though has no chance of taking the good, or not having the chance of using that building, for instance, in a lease agreement. The point is, the problems that I mentioned in the beginning of my presentation still exist, and they do not fit any of the provisions of the Brazilian Civil Code that lead us to a legal problem. Do we have a legal gap in Brazil? I do believe we do have a legal gap. And to provide answers to this legal gap, one has to stretch the requirements or the scope of application of the available devices, of the available figures. And in order to do so, I would say that it's most likely that Brazilian scholars will go to the impossibility rules than to the hardship rules. And that's actually for two reasons. The first reason I would say that, and it's a reason just based on the status from looking at the problems by now, that we don't have the time distancing to see how were contracts impacted by the coronavirus pandemic, meaning that there is no, today, it's very hard for us to assess that there has been an excessive onerosity and an extreme advantage to the other party. The second point is that differently from the rules on impossibility and force majeure, there are incomplete rules. The rule on hardship is a complete rule in Brazil, meaning that its scope of application is well defined, the definition is well done, and the consequence, namely determination of the contract, is also ruled by Article 478. That leads to a problem to trying to fulfill a legal gap by stretching too much a rule that it's very, very complete. If we look at impossibility, or if we look at the force majeure rules in Brazil, we'll find that those rules are not very complete, because there is no definition of impossibility and there's no definition of the consequences applicable to force majeure. I'm not stating that it's my personal, that I would like to say that that's impossibility or that force majeure rules that better. I'm just saying that from a methodological speaking, that's better to use this non-defined concepts than or the consequences that are not defined in the Brazilian Civil Code, and try to simply disconsider the complete provision that we have in hardship clause. Well, the point is that we live in uncertain times, and law has to provide certainty here. Yeah, the best way to do it is to stick to a legal system and try to build solutions that do not collide with the system. So we have the tools in Brazil, but we are still in an ongoing process to build those solutions. To end my presentation, and then I will return to the first words I said, that we have a universal problem vis-a-vis a specific solution or a local solution, not only local domestically, but I mean, by the contract, by the law applicable to the contract. The last time I think we had a problem comparable to this was after World War II. And now we have a very advantage time to do that. We have an advantage. It's a bad time. I don't think anyone is happy where we're living, of course, but we have an advantage. And the advantage is that we can now discuss, we can have a dialogue, and we may rely in comparative law and in comparative solutions to deal with these problems. So even though the solutions are to be found in a domestic, for instance, if Brazilian law is the law applicable to that contract, it has to be found here, we can actually discuss the same problems and understand how better these solutions can be provided within Brazilian law. And that's especially important in international arbitration and in international contracts, because then we can actually have an impact not only in the material understanding of a law, but also rethinking choice of law, either by arbitrators that can actually find the better solutions to that is suitable for that specific contract. So those were my words. Thank you very much for your attention.
Thank you very much, Renata. I think César has returned. Is César here with us?
Yes.
So with that, we'll start the Q&A part of our discussion, and I'll go ahead and Professor Schwenzer said that she did not have time to address a couple of questions of the application of the remedies of adaptation and renegotiation under the CISG. I would like to if at all possible, hear her opinion on this subject and the commentary of anyone else on the panel who would like to contribute. Does the CISG is adaptation and adaptation and renegotiation remedies available under the CISG in the cases of hardship, in your opinion?
Well, I think they are not available under the CISG, and I think we do not need them. The remedies that we have under Article 79, that means exemption from liability and damages and exclusion of specific performance, are enough. We do not need, if you have a remedy of renegotiation, I mean the parties, if they can, they will renegotiate. And we cannot force them to renegotiate. So that's regarding this remedy. And also adaptation. If the parties do not want to renegotiate, they do not want to adapt the contract. And why should a third party come in and adapt the contract? So this makes, and I think my colleague Professor Momberg has shown it. He said, well, it's totally unclear how arbitral tribunals or courts will apply these provisions. So what comes out is unpredictability. Not only whether a court or tribunal will adapt the contract, but what will the terms be of the contract. So I think and also it will take much too long. Imagine if a court is to adapt the contract, then you have several instances of court decisions. It might take 6-7 years till you receive a final decision of the Supreme Court with an adaptation of the contract. So that might not fit into this situation any longer. And then you have to enforce this court decision another maybe years to come till you can enforce it. So times have passed. So and now you have an adaptation of the contract. It doesn't make sense. So what is enough is that the party affected by the impediment, and I think this crisis has very well shown that we should not distinguish anymore between impossibility, force majeure, hardship, imprévision. It's all, and I think there the CISG is perfectly suited to deal with all of that. It's an impediment beyond the control of the affected party. So that's that is the crucial question. Is it an impediment, and not is it impossible or almost impossible or only very, very onerous? So, and I think the remedies that exemption from liability and exemption from specific performance, and then also it's not up to a court or tribunal to say the contract is terminated. No, it's up to the parties. And the other party who is affected by the non-performance can avoid the contract. That's the normal system we have, avoidance by declaration of a party, and that presupposes, and I think that is very, very important, and it makes things, again, much more predictable. It presupposes that the non-delivery, for example, is a fundamental breach. And only if we have a fundamental breach, then avoidance is possible, and not without any further prerequisites, a termination by a court or arbitral tribunal if they decide that it's proper in the circumstances. So I think the clear remedies by the CISG are enough. There are no other remedies that should be available.
Daniel, if I may just step in, I would very much like to hear our other speakers about how this reasoning that Ingeborg made based on the CISG interplays with the various national systems. Should this idea that all these different concepts at the end of the day amount to an idea of impediment beyond the party's control, should that in a way interfere with the interpretation of the various domestic systems, or as Renata dealt with Article 478 in Brazil with its very specific requirements and effects? Does that change in light of this of the magnitude of the problem that we are facing right now, and or it doesn't, and we should stick to our requirements under domestic law when the CISG is not applicable?
Yeah, if I can say something. Yeah. Okay. Yeah, yeah. First, I agree with what Professor Schwenzer has said. Maybe with one prevention, that I'm fully aware that if the parties want to renegotiate, they're going to renegotiate. They don't need any kind of legal provision saying that. I think, but maybe a legal provision encouraging the parties to renegotiate can be useful to avoid, for instance, that a party just said, I cannot comply with this contract and I'm going to terminate it. If you ask to that party to show to the other that he is willing to renegotiate, and then he can propose some voluntary adaptation of the contract, can be a useful tool. So maybe it can function as an incentive for the affected party just not to terminate, to discard the contract, but to propose a better solution if they want to work together after this disruption, of course, with the other party. And about your question, Cesar, in the case of Chile, we have a 19th century civil code. So the approach with regard to force majeure is very different from the CISG, of course. But I have to say that since I think in the last 20 years, more or less, Chilean legal doctrine based on the CISG and based on the UNIDROIT principles and other international instruments are trying to make a reinterpretation of our provisions of the civil code. And now I think we have agreement at the level of legal doctrine. I'm not sure about the case law. We are going to see it after all this happen in the next months, what in the next years, really, what the courts are going to decide. But at the level of legal doctrine, that the approach of Article 79 of the CISG is perfectly applicable to our for an interpretation of our civil code provisions. So we agree, as a legal doctrine, that it has to be an impediment, that it is that the other party still have available the other remedies like termination or whatever, and that it's not force majeure is not necessarily a cause of extinction of the obligation, but it's a case of non-performance, really. But of course, without any fault, so you cannot claim damages or something like that. But it's a new interpretation based on these CISG provisions, and especially also the soft law international instruments of contract law. But we have to see what the courts are going to say about this legal doctrinal interpretation.
Okay, may I take the floor? Well, with regards to Mexico, that would be also the case. I think that the provisions on force majeure, act of God, could be easily reinterpreted by our high tribunals, Supreme Court or appellate tribunals, to include not only absolute impossibility, but also impediments that couldn't be easily overcome, or because of the excessive imbalance in the performance of obligations. I think that would be the best solution. By hearing to the Brazil example, I think, as Renata said, we need to look at comparative law, because what Brazil has done in terms of hardship may make even more difficult to claim hardship than under force majeure or act of God provisions. So maybe we should stay as we are, and that is possible. I understand that the CISG Advisory Council is working on an opinion on hardship. So when it is translated into Spanish, it would be great to have a look at it in Mexico, to provide some tools to understand how Article 79 works for us in Mexico, is part of our national law, and how that could be used to reinterpret our provisions for B2B. And very fastly, I agree that perhaps the best solution in terms of remedies for hardship is multi-tier negotiation, multi-tier dispute resolution clauses in arbitration. Professor Schwenzer focused on the time and the difficulties that a state court may have to rebalance, adjust, modify, or terminate a contract. And we know that in arbitration it could be faster, but still, if that can be solved by the parties, it should be done by them. Someone has opposed the argument that arbitral tribunals can easily issue interim measures, but the interim measures that arbitral tribunals may grant in these situations involve actually deciding on the merits, and very few arbitral tribunals will issue an interim measure or emergency measure telling the parties from now on you should perform at certain price, right? Or under certain conditions. It would be like deciding the merits from the outset. So the bonds and guarantees that would need to be issued would be high. And so I think negotiation as a remedy agreed by the parties may be the best solution. Thank you.
May I?
Of course.
Okay. Well, I'll try to address both questions at the same answer. So Professor Schwenzer has pointed out that if force majeure occurs in CISG, then the creditor, the other party, could resort to avoidance, right? And that's a problem in Brazil, because avoidance in Brazil, CISG, of course, and I wouldn't dare talking about CISG in front of Professor Schwenzer. Yeah, the point is that in Brazil, avoidance is possible. It's a possible remedy in two situations. The first one is when the performance is rendered impossible. Then we go back to those articles that I just mentioned in my presentation. The second one is when, due to the delay, that the creditor interests in performance is lost. Well, those two provisions on avoidance in Brazil do not fit actually the occurrence of a force majeure event that does not render it impossible to perform. So we don't have impossibility and we don't have termination. And second of all, as a force majeure exempts liability and also exempts the delay, there is no delay because there is no liability, and that's exactly what our civil code says, then we don't have the possibility to avoid a contract due to the loss of interest because there is no delay. So we have a legal gap in Brazil. This legal gap will have to be found, or will have to be built by the possible solutions. The possible solution is either stretch the impossibility and terminate a contract, which is a little bit against the last resort of avoidance. And the second one would be to review the contract, and that's giving the arbitral tribunal or the tribunals a power that I don't know. I'm not sure if they have, as per the Brazilian civil code. And the third possibility is for the parties to renegotiate. So maybe in Brazil, as long as we don't have answers to those questions and we have this legal gap, renegotiation will be the easiest way out of this trouble we're in. But that's not something that we can build from Brazilian civil code. There is no duty to renegotiate. Some scholars, and I mentioned in my presentation, Professor Schreiber, he has a book on it, on renegotiation, and he would say that renegotiation has as source the good faith principle. I think that goes too far away with good faith. I don't think that's actually something that we can build from good faith. But that said, I think that it's most likely that the CISG remedies are more complete than in Brazil's remedies. So Cesar has asked, oh, what about if to apply a domestic rule where the CISG does not rule that specific situation? I don't think that Brazil will be able to provide those answers, because I think we have an incomplete panorama of that, of the situations that we're facing.
I think this panel shows the wisdom of using the CISG, for instance, among these countries that have such different domestic systems, and there'd probably be a very large cultural clash between an Brazilian party and a Mexican party looking at the same problem under hardship, as per Edgardo and Renata. But let me make a provocation to Professor Schwenzer and to everyone else on the panel. Truly, how bad is unpredictability in unpredictable times? When Professor Weinsheimer has a position on the duty of commerciality of international arbitrators. His position is that because international arbitrators are guardians of the international commercial order, within the confines of the applicable law, the arbitrator should strive to apply the most commercially reasonable solution that the law would give to that problem. So yes, that will create a problem of unpredictability. But what is actually better in these unpredictable times? Having a predictable but commercially disastrous answer to a problem, or to having an answer that is a little bit less predictable, but much more commercially viable? Well, what is your feeling? What is the panel's feeling on this provocation?
Well, the question is, what is commercially viable? And in an international arbitration, we will have normally 3 arbitrators from 3 different countries, from 3 different cultures, and they all will have a different perception of what is commercially viable. So I think indeed, I would value much higher predictability for both parties than to rely on domestic conception, because arbitrators, although acting internationally, they come from a certain legal system. So they will have their own notions about commercial sensible solutions, which will be influenced by their domestic legal systems and not by the law that is applicable to the case. So I still stick to predictability than to some vague notions of commercial viability.
Anyone else?
Yeah, I just want to say I agree with Professor Schwenzer, and I would say that I think predictability is the best commercial solution. There's no position between predictability and the best commercial solution. Predictability is the best commercial solution. So yeah, that's my answer.
Perfect. There is a question made by Victoria Zanotto Farina in the YouTube feed. She asked, can the inclusion of an Incoterm to a sales contract be regarded as the assumption of risk of the events imposed by COVID-19?
May I ask? May I respond to that one?
Of course.
Okay. Yes. Agreeing on an Incoterm distributes the risks on the merchandise, on the goods during the period of performance, during the period of delivery. So usually if, let's take a clear example, if you agree on FOB and you are unable to FOB deliveries when you put the merchandise on board. If, as the seller, you are unable to put the merchandise on board because they were destroyed before getting to the ship, well, that is your risk, and you have to perform the contract unless there is force majeure with regard to the goods, or there is an impediment. If the goods were to be a painting of Picasso, a specific painting, you cannot perform again. So you would be exonerated even if you agree on that Incoterm, if the painting was destroyed before you comply with your obligation of delivery. But if the goods were generic, you will need to try it again until you do it. Because with generic goods, you can overcome generally the impediment. So you try it again unless it becomes excessively onerous, and then you need hardship provisions, right? Or to distinguish between how difficult it would be to overcome the impediment. In terms of enforceability, there may be many issues we didn't talk about, but the pandemic was already in Italy hitting hard, when in Mexico the federal government was still shaking hands. You see what I mean? So it's a nice analysis of all these risk allocation as well, and requirements for impossibility or impediments in general. That would be my answer.
Anyone else? Go ahead.
No, I was just going to ask another question. So if would anybody else like to comment on what Edgardo just said? I was curious here about one issue. We see that in many cases, maybe in most cases, contracts are not affected by the pandemic itself, but are affected by acts of states in reaction to the pandemic, acts that may be proportional and necessary, that may be exaggerated at points. There is a whole discussion about how far should states go in that regard. But but assuming those acts are proportional and they're needed, and they are taken in the public interest of preventing the spread of a disease that affects everyone. Does that make a difference in terms of the application of these concepts that affect contractual obligations? Because just to give you an example, in certain situations, one party may be, and Ingeborg mentioned several of those cases, may be prevented from performing its usual activities in order to benefit from the contract as it intended to originally, or may be affected by other state measures, not for any other reason than to benefit the, let's say, society as a whole in terms of prevention of the spread of the disease. How does that affect these concepts of impossibility or force majeure or acts of God or anything else, or impediments in general, given this very specific nature of the impediments, not one that happens by accident, but one that is taken by states in the interest of basically everyone, including the party that benefits from not being affected contractually by those acts. Does that make a difference, or is it the same thing we've been talking so far?
In other words, not the act of God itself, but the factum principis caused by the act of God. The effects of the factum principis caused by the act of God rather than the act of God itself.
May I start? Yeah, so in Brazil, I don't think that makes a difference, because the concept of impossibility, that the three qualifications, so absolute, objective, and definitive, it also englobes the what we call legal impossibility, which is the case. So it's not only the natural impossibility, but also legal impossibility that it's complied with the concept of impossibility. The problem of this kind of regulation says that is that it's a temporary regulation. So it's not an impossibility at all, because it's not definitive. And then we have a problem of how to deal with this concept in Brazilian civil law. But the concept of natural impossibility or legal impossibility does not make a difference. So we don't have to rely to the impossibility. We don't have to rely on the force majeure event, and to force majeure does not always lead to impossibility. That's what I intended to say. Most likely a force majeure event will render it impossible to perform, and most likely an impossible performance will be due to a force majeure event, but it's not really necessarily to have this combination together. And the example you gave is just one of some of the examples where we have an impossibility, but we don't have a force majeure event.
I don't know if I...
Yes. May I add something for the international level? Well, usually we ask ourselves if there is an act of government making performance impossible or more onerous. We ask ourselves whether this act of government is within the sphere of the risk of the party that is affected. So that would mean if a government closes down the factory of the seller, that in principle, how we interpreted Article 79 up to now would be within the sphere of risk, more or less, of the seller. But I think we cannot apply this principle in these days, because manufacturers around the world have been affected in the same way. And there has been a lockdown in most of the countries now. So I think we should, as you said, in Brazilian law, we should also at the international level at that time equate the act of government closing down the factory of a manufacturer or prohibiting export to a certain country with the factual impossibility to produce, so where the factory has burned down or something like that.
Yeah, I just, may I? Just briefly, with regard to Chilean law, really the nature of the event, of course, it has to be external and out of the sphere of risk assumed by the parties and unforeseeable. But if it is a natural event or a human event, doesn't make any difference. The importance is related with the effect of the event on the performance of the obligation. So if it is, the effect is to make impossible to perform the obligation, that will be force majeure or whatever. And if it is not impossible, then we speak of another kind of issue, maybe hardship or change of circumstances. If it is admissible, I don't think, I'm not sure about it, but the nature of the event is not relevant. It's the effect of that event on the performance of the obligation what makes it force majeure or not, really.
And if I may add, the question of Cesar trigger a consultation I had some days ago regarding the requirements to raise the exemption of force majeure. As you know, you can allocate risk, you can modify the definition of force majeure, you can subject it to requirements under the vast majority of countries. And there was these two enterprises, construction enterprises in one of the states in the north of Mexico. One of them, the creditor was compelling by several notices to perform its obligations. And the contractor said, I cannot do it. I cannot do it because the government has issued this emergency decree. And the other party said, well, even if that constitutes a force majeure under our contract, you should have give notice within 10 days of the force majeure event and set a time for performance later, a period of time where you have to perform that obligation. And there are several contracts with those clauses, at least around here. And without giving a decide in this case of giving an opinion, I think most of these requirements, when the force majeure comes from an act of government, became superfluous, or at least should not prevent one party from relying on force majeure. First, because these events are widely known. I mean, what notice does supposedly the owner of the works wanted if it was all around the news, the origin of that force majeure? And in terms of the period of grace to perform, it was impossible to know when the government would lift the restrictions. So just as an example of how requirements, with contractual requirements, may be also reinterpreted or affected depending on the origin of the impossibility. Thank you.
Thank you. We are actually approaching the end of our allocated time here. And before I turn to Daniel to ask you a final question, I just wanted to make a quick comment. This video is going to be available at the Chartered Institute of Arbitrators Brazil branch website and on our YouTube channel as well. So probably by tomorrow it will be the whole thing, the whole 2 hours of discussions will be available there if anybody wants to watch it again, or if anybody has, any of your friends have missed it, be sure to tell them that it's going to be available there. So Daniel, I turn to you now for the closing procedure.
Thank you, Cesar. Before closing the presentation, I'd like to give the floor to each of the presenters for any closing remarks, or in a minute or so. Professor Schwenzer, if you would like to say something to sum up your whole position on this, and then everyone else in the order of the presentation.
Yeah, I started in my presentation when I came to the conclusion. I mentioned that I'm convinced that any international solutions are much better than any domestic solutions. And for me, our presentations have clearly proven this statement. So I would urge any persons who are in charge of drafting contracts, not international contracts, not to opt out from the CISG and opt into some unpredictable domestic law.
Thank you. Edgardo?
I think I will join Professor Ingeborg Schwenzer in her last comment. For many reasons, international instruments are better equipped and designed. So that would be for me the same. Thank you.
Professor Momberg?
Yeah, thank you. Yeah, I also agree with Professor Schwenzer. Not only the CISG, but also all these really international corpus of contract law, which we can refer like the unilateral principles, especially with a lot of legal doctrine, and each day with more references by the case law to the unilateral principles and the CISG. So it's a very good option to choose a kind of contemporary international contract law beyond our national borders. So yeah, that will be my closing remarks. Thank you very much for the invitation again.
Thank you. Professor Steiner?
Yeah, well, I have to agree with Professor Schwenzer, but as a Brazilian attorney, I have to also say that I look forward for us in Brazil to build some solutions that are very fair to this situation. So, and there are a lot of countries in Brazil that are ruled by Brazilian law, and as you know, we have very live discussion about the possibility of choosing the law that will govern the contracts in Brazil. So meaning that many of the contracts in Brazil are going to be, unfortunately or not, are going to be ruled by Brazilian law. And I hope that we can dialogue with international conventions and the CISG scholars that are very, have been successful in so many years of CISG to build good solutions in order to find some solutions to our domestic law as well.
Yeah, and then that's exactly the last remark I would make, is that we have the possibility now, when our legal systems are not sufficiently well prepared to deal with these situations, to look at how it is done elsewhere. And try to maybe incorporate either at the supranational level, like the CISG instruments, but also looking to our neighbors and see how our neighbors deal with similar situations. So I'd like to thank the Chartered Institute of Arbitrators for the kind invitation to be a moderator, just among giants that are presenting their positions today. It is truly an honor, and I think this was a great event where we had the opportunity to look at how the systems of Latin America and the CISG and the unilateral principles deal with the unpredictable times that we are living right now. So I hope everyone had a great event. Please, if you're in Brazil and you work with arbitration, get in contact with César Pereira to learn more about the Charter Institute. He has been doing a brilliant job as our chair for the inaugural term of the Brazilian branch. And for everyone else who has stayed with us up until now, thank you very much for your patience, and thank you very, very much for your comments. Everyone, Professor Schwenzer, Professor Edgardo, Professor Momberg, Professor Steiner says thank you very much, and you all have a great day. Bye-bye.
Thank you. Bye.
Thank you very much.